An insurance company faced multiple claims from a single accident. Could it force them all to be heard together? The court held that it could, in Pan American Fire and Casualty versus Revere. A truck collided with a school bus in Louisiana, killing 4 people and injuring 23 others. The victims filed 3 lawsuits and made numerous other claims against Pan American Fire and Casualty Company, or Pan American, the truck's insurer. Pan American instituted an interpleader action against all potential claimants, seeking to enjoin them from suing elsewhere and make them assert their claims in a single proceeding. Pan American deposited a bond in the amount of its policy limits, disavowing any interest in the funds, but not admitting liability. A potential claimant sought to dismiss the interpleader action. The court considered whether interpleader is appropriate for competing unreduced tort claims against an insurer. The court held that interpleader was appropriate. Judge Wright explained that historically, courts distinguished true interpleader, in which the plaintiff is a disinterested stakeholder, and actions, quote, in the nature of, unquote, interpleader, in which the plaintiff is also a claimant or challenges the claims to the funds. An old rule of equity held that potential exposure to multiple lawsuits on the same obligation was sufficient grounds for equitable relief only in a true interpleader. However, both Federal Rule of Civil Procedure 22 and the Interpleader Act eliminate this distinction. Even under the modern rules, not every party threatened with a potential multiplicity of suits is entitled to interpleader, which is meant to protect debtors against multiple claims for the same funds. Any possibility of owing more than is due, no matter how remote, suffices. Here, Pan American faced potential claims in excess of its policy limits, so it could properly seek interpleader. Claimants must also be adverse. Here, the claimants were theoretically indifferent to each other's claims, but were competing for the same limited pool of funds, which satisfies the adverseness requirement. Interpleader isn't available if the hazard the plaintiff seeks to avoid is his own fault. Therefore, interpleader likely wouldn't be available to the truck driver, but Pan American isn't to blame for the actions of its insured.